Followed by the pledge of allegiance to the flag. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. At this time, I'm required to state that adequate notice of this meeting has been provided indicating the time and place of the meeting in accordance with Chapter 231 of the Public Laws of 1975 by advertising a notice in the Star Gazette in the Express Times and by posting a copy of the bulletin board of the municipal building. Beth, may I have a roll call at this time, please?
Yes, members Down, Camperine, Clymer, Coyle, Curry, Dagan, France, Lance,
Here.
Stewart, Wolf, Chairman Zampley.
Here. The only business that will be conducting tonight at the special meeting is the continuation of the hearing of 189 Strikers Road, Block 100, Lot 6, Asphalt plant application for preliminary and final major site plan approval. In conjunction with that, I would like to indicate that we will different order of procedure this evening. We're going to have each remaining applicant expert testify in sequence one at a time. The board questions each expert at the conclusion of their testimony. We'll pack on citizens, question them each in sequence. Any interested parties may question the expert. Each questioner shall have 5 minutes to present. The questioner shall approach the podium only once with each applicant. At the conclusion of the applicant's case, the interested party shall be placed under oath. They address the board with any statements, objections, or support of the applicant. Each interested party shall be limited to 5 minutes and be subject to cross-examination by the applicant's attorney. The chairman reserves the right to control repetitive questions and may deny witnesses from asking the same question over and over again. With that, we'll proceed.
Just for the record, procedurally, Jonathan E. Drill, I have a pending request to dismiss the application for
Mr. Drill, I'm ruling you out of order at that point. You already have the answer to that from the Highlands Commission.
I believe that's the answer to the Highlands Commission, but I think the board, if you don't want to rule on my request, you don't have to.
You made the request.
I made the request.
You want to not enter the application?
I made the request of this board to dismiss the application for lack of jurisdiction. I acknowledge that there's a letter from the Highlands, and I acknowledge there's a letter from Mr. Minnick. I think it's better practice to rule on the request. You don't have to if you don't want to.
I've reviewed the letter sent by Mr. Drill. I've reviewed the letter sent by the Highlands Board of Protection and Planning Council, and I am advising the board that we can continue tonight with the application, and that I do not feel that we've lost jurisdiction in any way on this matter. I don't feel we've lost jurisdiction on the matter at all.
And then the follow-up request would be to put this off because I have suggested to my client, recommended they have to meet, that the Township of Greenwich appeal the Highlands decision to the Appellate Division, and it would be a waste of time to go on with the hearing if the Appellate Division reverses it. So that's my second request, to postpone the hearing until after the appeal is filed and disposed of.
All right. Does the applicant have any?
Yes, Mr. Chairman, Dean Stein. First, we would note. Can you hear now? Yeah, thank you. First, we would note it's not for this board to decide if the municipal ordinance is valid or invalid. It's for the Superior Court to make that determination. You have to presume that your ordinances are valid, and your attorneys made the call. Secondly, if we wish to proceed, we believe that first, if you're going to determine an ordinance is invalid, you have to go to the Superior Court. There's the Appellate Division, there's the Supreme Court. They can stretch it out for years. We'd like a decision from this board, and they can take whatever steps. In fact, one of the attorneys here has challenged the ordinance in Superior Court. That's the right step to take. And if Mr. Drill wishes to, he can take that stuff as well, but we'd like to proceed. We have a legal right to proceed tonight. Thank you.
I'm recommending to the board that we proceed.
Bill, would you state definitively who you actually represent? Are you the town council or the planning board? I mean, I'm here.
I have done this before, but I'll do it again for you. I represent the Township of Greenwich. The mayor and the township committee have retained me as their special land use counsel to represent the Township of Greenwich in this application, first as a concerned party, now as an objector, because the conditions that we asked the applicant to agree to and propose to you to be attached to any approval, they only agreed to the conditions restricting truck traffic on certain roads. They didn't agree to the others, so Greenwich is actively objecting to the application. I represent the township, no individual citizens of the township. I happen to also represent the planning board there in the Board of Adjustment, but that's irrelevant.
But you're not representing their planning board here tonight?
No, the planning board is not appearing in front of some other planning board objecting to some application. Their Board of Adjustment is not appearing in front of this board objecting to any application. My sole client is the Township of Greenwich, who is appearing here to object to this
Okay,
application.
there's been a lot of misinformation around.
A lot of things reported in the paper, but everything I've told you remains the same.
Okay. One other question. Have you ever been associated with, or now you associated with, Drill Construction?
Yes, that's not anymore, but that was my father's in that business, my brother's in that business. I am not in that business. I don't own any stock in that business.
Okay. Thank you very much.
Thank you, Mr. Chairman, members of the board. Again, William G. Menon here on behalf of the applicant. Consistent with your earlier pronouncement, Mr. Chairman, we'd like to call our first witness of the evening, our professional engineer. Raise your right hand, please.
I do. Evan Smith.
Thank you, thank you. Mr. Smith, what is your occupation?
I'm a professional engineer licensed in the state of New Jersey.
And by whom are you employed?
Finelli Consulting Engineers in Washington, Warren County, New Jersey.
Have you appeared before planning boards or boards of adjustment in the state of New Jersey and been accepted as an expert in the field of professional engineering?
Yes, I have.
Have you ever been accepted as a professional, as an expert in professional engineering before this board?
Yes.
Mr. Chairman, I would ask, unless there's any further point here, that Mr. Smith be accepted as an expert in the field of professional engineering. Mr. Smith, did your firm prepare the plans submitted as a part of this application?
Yes, we did.
You were here a couple of meetings ago and heard me state in my opening remarks, Mr. Smith, that the applicant is agreeable to and has no issue with the comments or suggestions made in the review letters of Mr. Sturbins and Mr. Ritter. Can you confirm that now for the board?
That is true. We've had a chance to review the letters from the board's professionals. We take no issue with those comments.
Turning to previously marked Exhibit A4, can you briefly describe the site location, lot size, and zone within which the property resides?
Yes. Exhibit 4 is our color rendered plan of the site. The property itself is currently identified on the tax map as Block 100, Lot 6. It is a 15.4 acre parcel of land, located with frontage, 60-foot frontage along Strikers Road. It's got a 60-foot access stem, and then it widens out to a large developable, or mostly developable portion of land. as you get past the 60-foot stem.
And which zone district is the property located within, Mr. Smith?
The property is located in the Research Office Manufacturing Zone, the ROM zone.
What is the current use of the site?
Currently, the site is primarily in row crop. The latest crop was corn. In addition, there is a gravel area just to the south, just to the southwest of where the property widens out. That is currently it's got gravel material and is being used to store some equipment. The other feature on the site is that there is an access drive that is partially paved and partially in gravel that runs along the southeasterly boundary of the property adjacent to the precast concrete facility next door.
Mr. Smith, I think if you'd refer to the exhibit that was previously marked as A1, I believe that's up there behind the board.
Yes.
Put that up on the stand. Utilizing that exhibit previously marked as A1, would you identify the neighboring land uses after first identifying the subject property on that exhibit?
Yes. The exhibit is an aerial image taken from the internet and reproduced. I'm highlighting now roughly the center of the subject parcel. The access, I'm highlighting the access point along Strikers Road. The uses that surround the subject property to the southwest, showing you see a number of long buildings here. This is the stowaway self-storage lot, which is again to the southwest. To the northwest is an adjacent tree farm that is separated from our site by a tree row. To our northeast, there are two facilities that abut our property. One is a light manufacturing facility, and the other is a trucking facility. And then lastly, to our southeast is the precast concrete manufactured plant.
Just for the purposes of the record, Mr. Smith, did you identify the parcel across the street on Stryker Road and what function that parcel currently?
There's a fairly large manufacturing facility. I'm highlighting now Strikers Road. Now on the other side of Strikers Road would be to the northeasterly is a manufacturing facility called Captive Plastics.
And how far away is the nearest residential dwelling from the subject property?
The nearest residential dwelling from the boundary of our site is approximately 900 feet. That property is located on Lock Street or Lock Street. I'm highlighting that area on the plan right now. Again, it's 900 feet from that structure to our boundary. The other nearest residences, again, I'm going to tell you from the boundary of our property to the residence along Route 57 near the school. That distance is again boundary to boundary, approximately 1,275 feet.
Have you performed that same measurement, measuring not from the boundary line, but from the area that's proposed to be developed with the manufacturing facility proposed for this parcel?
Yes, I have. The approximate distance from the plant itself to the property on Lock is in excess of 1,500 feet, and from the plant to the property on on the other side of Route 57 is approximately 1,600 feet.
Would you just briefly describe the site terrain?
Yes, the site is gently to moderately sloped. In the direction of the slope is from generally from Stryker's Road towards the self-storage facility.
Would you just briefly again highlight the current access to the site?
Yes, the access is essentially, if you look at the corner of where the strip of road between the trucking facility I mentioned before and the concrete precast lot, that's where you'll find our access.
Is it correct that there's a JCP&L right-of-way which traverses the site?
Yes.
Would you please describe that?
The JCP&L has a 300-foot wide utility easement that traverses this area of Lopatcong Township and Greenwich Township. Again, it's 300 feet wide. A portion of that easement encompasses the southwesterly side of our site. I'm going to highlight that with the pointer. And the portion that is on the portion of that 300-foot easement that is on our property measures 220 feet. And on Exhibit A1, you can see I'm pointing to one of the towers, one of the high-tension towers that are located in that easement.
And you indicated earlier, Mr. Smith, that the subject property is in the township's ROM zone. Is that correct?
That's correct.
What is the minimum lot size for a conforming lot within the ROM zone?
5 acres.
Would you briefly describe what is proposed by the applicant as part of the subdivision application?
Yes. Once again, referring to Exhibit A4, our colored rendering of the site, we propose to create, well, first let me tell you that the lot itself is a 15.4 acre parcel of land, and we propose to create 2 building lots. One being 5 acre in size, as I highlighted on Exhibit A4, and then the balance, or I should say the second building lot, which will be the location of the proposed asphalt plant. That lot measures 8.78 acres.
You've described the access as it currently exists. Would you describe the access proposed for both proposed lots 6 and 6.07 depicted on A4?
Yes, we're going to create an access for these 2 buildable lots. It's going to encompass that 60-foot wide access stem, and it's going to continue into the property, terminating at a cul-de-sac bolt.
You've indicated on the submissions to this board that access strip is a private street. Is that correct?
That's correct.
And is that private street going to be improved to private standards or to public standards?
The street is going to be improved to public standards, and what that means is that the dimensions of the horizontal dimensions of the road and the cul-de-sac, as well as the construction specification for the pavement and the vertical alignment of our roadway will meet township standards for an improved public road.
So as this proposed accessway is a private street, is it correct that proposed lots 6 and 6.07 do not abut a public street?
Yes.
Is the applicant seeking relief from the requirement that the lots abut a public street?
Yes.
Is there an alternative means of access which would avert the need to request relief from the requirement that the lots abut a public street?
Yes, we could dedicate this private street to the township.
And you've indicated that the design as proposed is sufficient to construct a public street.
That's correct.
And in your capacity as a professional engineer, why do you feel it would be a benefit to keep the access proposed in private ownership as opposed to making it a public street?
This street serves two industrial pieces of property. And by keeping it keeping it as a private street, that will mean that the township does not have to take on or bear the responsibility for maintenance, snow plowing, liability insurance, things of that nature. So that would be the responsibility of the owner of Lot 6.
Will the private street as proposed assure adequate access to both lots for emergency vehicles?
Yes.
Is there any proposed change, Mr. Smith, to the use for proposed lot 6.07?
Lot 6.07 is that vacant piece of property. There's no plans for a development application on the property at this time.
While the applicant proposes to create two lots, the subdivision plan that you prepared and submitted contains a third identifier, namely lot 6.08. Is that a third lot?
No, that is the private street.
And that designator 6.08 does not appear on the site plan that you prepared, correct?
That's correct.
And you indicated that that designator refers only to the private street, correct?
Yes.
And isn't it correct, Mr. Smith, that under tax map regulations, township officials would have administratively assigned a lot designator to that private street at the time of final plat?
Yes, they would.
So is it correct to say that you simply placed the designator 6.08 on the right-of-way or private street to be proactive?
Yes.
I'd like to ask you now some questions, Mr. Smith, concerning the site plan. You were here earlier and heard the testimony of Mr. Midzak, where he outlined the applicant's proposal to install and operate an asphalt manufacturing facility. How will that facility he identified be accessed?
Access will be from that private street that we discussed a few minutes ago.
With regard to the stockpile of material that Mr. Midzak testified to previously, with a 25-foot height, will that comply with the zoning ordinance as to height and then as to corresponding buffer requirements?
Yes, because the piles exceed a height of 14 feet, we needed to increase the buffer, and our buffers actually exceed that minimum requirement.
Will the amount of coverage proposed comply with the local ordinance?
Yes.
In accordance with local ordinance section 243-77.6E, silos can be up to 85 feet in height, but this requires increased setback and buffer. Do we comply with those setback and buffer requirements?
Yes, we did.
Does the application comply with all other setback requirements?
Yes.
Does the application comply with height restrictions in the zoning ordinance?
Yes.
Will any trees, as defined by the municipal ordinance, be removed?
No.
Are you familiar, Mr. Smith, with the conditional use standards for the use proposed in this ROM zone?
Yes, I am.
Does the use proposed comply with those standards?
Yes.
Concerning the access to Stryker's Road from the private street, will proper site distances be achievable?
Yes.
With regard to landscaping, comments and suggestions have been made in the review letters issued by the board's professional planner and professional engineer. Does the applicant have any problem agreeing to and complying with those suggestions?
I have no problem with that.
Would you please describe the site lighting as proposed?
Yes. The site lighting, there are two types of fixtures we propose that will be built to the site. The first has to do with the private street itself. And per the recommendations of the township, we are installing what would be the typical JCP&L street light. It's essentially, looks like a colonial headpiece. Those poles are 16 feet in height, and they have a wattage of 175 watts. And then for the site itself, we are using a traditional, if you will, a shoebox type fixture. Those are 30 feet in height. They are 400 watts in candle power.
Will there be any glare on neighboring properties?
No.
Mr. Smith, are the soils on site sufficient for the installation of an on-site septic system?
Yes, they are. We have an application before the county planning board now and expect to have an approval within the next week or two.
In section 2 of his review letter entitled Subdivision Plan, Mr. Sturbins makes several suggestions. Does the applicant agree to comply with those suggestions?
Yes.
Earlier, you heard Mr. Mitzak testify that there was agreement with the owner of lot 6.05 concerning the grant of an easement for stormwater discharge. Have you been involved in any of those discussions with the adjoining landowner?
Yes, I have.
Based upon those discussions, do you agree with Mr. Mitzak's confidence that such an easement will in fact be obtained and executed?
Yes, it will.
If for some unforeseen reason the applicant is unable to finalize that easement, are you confident that an alternate discharge method can be designed and implemented which would satisfy the requirements of all applicable standards?
Yes.
Will the applicant agree to a condition that either it produce such an easement or design an alternate solution to engineer Sturbins' satisfaction?
Yes.
In previous testimony before this board, you opined that the May 17, 2002 three-party right-of-way agreement would not need to be revised to accomplish the design proposed by the applicant. Is that still your opinion?
Yes, it is.
In section 3 of his letter entitled Layout Dimension Plan, Mr. Sturbins makes several suggestions. Does the applicant agree to comply with those suggestions?
Yes.
In section 4 of his review letter entitled Grading, Drainage, Utilities, Mr. Sturbins makes several suggestions. Does the applicant agree to comply with those suggestions?
Yes.
In section 7 of his review letter entitled Geotechnical Evaluation, Mr. Sturbins makes several suggestions. Does the applicant agree to comply with those suggestions?
Yes.
And lastly, in section 9 of his review letter entitled Miscellaneous, Mr. Sturbins makes several suggestions. Does the applicant agree to comply with those suggestions?
Yes.
Turning now to Planner Ritter's review letter, in section 2.2, he suggests that the location of the gate proposed be depicted on the site plan. Could you identify the location of that gate now, and then identify for the board whether or not the applicant agrees to comply with that suggestion?
Yes. Mr. Ritter correctly noted that there is a gate, or it's basically a chain type mechanism for closing off a driveway, and where that's located is actually right at the end of the cul-de-sac. If we have vehicles coming down the private street, we don't want them to inadvertently continue down the paved driveway beyond the cul-de-sac bulb. So there's a chained gate, if you will, at that location.
And does the applicant agree to depict that on the site plan?
Yes.
Mr. Smith, even if the applicant's application is approved by this board, aren't there other approvals or permits which must be obtained prior to the commencement of operations?
Yes, there are several.
Stormwater?
Yes.
An LOI?
Yes.
Septic design approval?
Yes.
Mr. Smith, did the applicant submit an EIS with this application?
No, we did not.
Was one required?
No, the ordinance has no specific requirement to submit an EIS.
Did you prepare and submit an EIS with the prior application to this board concerning this use?
Yes, we did.
Is that prior EIS applicable to the current application?
No, it's not part of this application.
I have nothing further on direct at this time, Mr. Chairman.
Are there any questions from the board or board professionals at this point?
I don't have a question specifically on this particular area, but I do have a question. Did the Alpha Board Planning Board ever officially reject this policy, this project?
Did who?
The Alpha Planning Board, did it ever officially reject this particular project? Yeah,
This project?
Yeah.
This project's in Lopatcong.
I know, that is my point. There are a lot of people here who have the assumption or feel that...
I don't know the answer to this.
We're prepared to stipulate. While this is indeed a separate application, but to answer your question, any application that was before the municipality you speak of, Alpha, was voluntarily withdrawn by this applicant.
Thank you, that's what I wanted to hear.
Order, please.
Okay. Now? Okay. I just wanted to note to the board and the public that Mr. Smith's interpretation of our ordinance is correct. There is no requirement for either a major subdivision, in a major subdivision, or a major site plan to submit an environmental impact statement. There is a requirement to submit a community impact statement, which was done. It's my opinion, quite honestly, if there had been a requirement due to the disturbed nature of the site, that this applicant would have been due at least for a partial waiver of that type of ordinance if there was one that was in existence. The site is significantly disturbed due to the farming use and the structures that are on the site right now. I think the impacts of this development have been addressed by the various other reports that have been submitted, as well as the experts that have been provided to this board, namely the air quality. Some of the reports we're looking at in this application are our stormwater report, our geotechnical, geologic report, our traffic report. So I think those are some of your more major impacts, and some of the things that are in the community impact report are addressed by those various reports that are on the record at this point.
Any other programs? Your comment or question?
I have one additional point to make. The applicant has agreed to basically respond to all the comments in our review letter. It should be pointed out that one of those comments deals with additional landscaping, and the applicant has agreed to provide additional evergreen landscaping in the buffer areas along the entrance road, in addition to those that are shown on the plan. So there will be an amended landscaping plan with additional plant material provided.
Thank you. Any further questions of the board? If not, I'll open it to the public. Is there anyone that wants to cross-examine this witness? Pardon?
Can you state your rules on who gets, I think I have to ask last because I don't represent someone in Lopatcong, as I understand it.
Well, we're going to each expert that testifies for the applicant will be able to be questioned by the board immediately after his testimony. We will then open it up to the public.
Does that include me, is what I want to know?
Well, we're part of it.
First. That's what I want to say. You will have the opportunity to go back. Okay.
Do you have a question? I can't hear you from here.
Can you just go over?
Would you please approach and identify yourself, please? Please state your name, where you live.
Yes, thank you. Marla Enden, 10 Byron Drive, Phillipsburg, New Jersey. Oh, we don't know?
You say Phillipsburg, or are you actually?
I'm from Lopatcong. My question is, would you please go over the statements you made first thing before we started about the public about 5 minutes, but then I thought I heard you say something about make statements to the board, and that kind of threw me off because it sounded like public comments might be getting mixed into that.
No, I'll read it again.
Thank you.
The applicant, for each remaining of the expert testifying in sequence will be one at a time. It won't be a mass.
One expert at a time.
One expert at a time. The board will then be able to question each expert at the conclusion of their testimony, which we just did. Then we'll back on citizens, question them each in sequence. In other words, this gentleman who testified as a professional engineer, the Lopatcong residents will be able to ask him questions. Then other interested parties, as this gentleman indicated, will be able to ask questions of that expert at that time. We're going to allow each questionnaire, Lopatcong or outside, 5 minutes for their questions. And they'll approach the podium only once for that person. We're trying to eliminate the duplicity that's been occurring in the last few sessions. So those are the rules.
And there wasn't another statement made after there about statements that I thought I heard addressing.
Let me explain. After the applicant is finished with his application, anyone who has anything to say, whether it be any interested party, would be able to come up and make a statement. In other words, I object to, or I'm in favor.
So that has not changed. We're talking about at the conclusion of all the extra testimony.
That's right.
Great. Okay, so while I'm up here, a question for the planning board. There's a lot of concern from the public about the air quality and the plant operations manager that we never finished the cross testimony last week. So are we going to have these folks up on deck again so we can finish that?
We're going to go through the rest of the...
Or what's the lineup for tonight?
The lineup?
Yeah, like, who are we hearing from? Who's on deck?
At this point, obviously, you just heard direct from the professional engineer. I think it's probably makes the most sense from a consistency standpoint to to do the cross-examination of this witness. We do have every other witness who's been here before is here this evening. So, however, Mr. Chairman, members of the board who wish to proceed, we've got them here and we're prepared to answer whatever relevant questions are posed of the witnesses.
Thank you.
That's fine.
You're gonna, as I understand, you're gonna cross-examine the engineer at this point.
The engineer will now be further.
And then we will be able to pick up where we left off with air quality and with the plant operations manager, correct? Cross-examination.
No, not with
No,
the
we
plant
won't be able
manager. Not with
to?
the plant operations manager, that testimony was concluded already.
No, we never finished the cross-examination. You can check the transcripts, I'm sure it's in there. We didn't finish, we had to stop the meeting at that point.
Mr. Chairman?
Mr. Chairman,
Yeah.
he's here, he will answer questions.
Okay.
Thank you so much. And then, I actually do have a question.
Are you making a statement? Or?
No, a question for the engineer.
Go ahead.
Sure. Hi. So I think at the very beginning of your testimony, you mentioned something, a graphic, I think it was an overhead view. Where did that graphic come from? No, the first one. The first. No, not that. The aerial. Thank you. Where did you get that from?
That was a, I believe it's a Google.
A Google? You Googled that? Oh, you missed it. Last week we were told that we can't use the internet to introduce any information.
Mr. Chairman, Daniel Bernstein again. There's a difference between using articles from Google that have a point of view that can't be cross-examined and aerial photographs that were taken that are recognized source. Clear difference, and we believe this would be outside the hearsay rule.
I'm sure that's fine with you, right?
No, wait, just a minute. There are rules. There are distinctions that we attorneys recognize in these things.
That's correct.
So then, just to clarify,
Are you asking a question?
how many feet is that accurate to from the picture from Google?
Excuse me, were you just coached by this gentleman here?
I don't even know who that is.
She can ask a question.
Are you representing her?
Absolutely not.
Sit down, please.
Excuse me, I believe that.
Sit down, please.
You're saying I'm not allowed to talk? Sit down.
You're not allowed to coach her or...
Okay, so then if we can use certain things from the internet, maybe at some point that can be defined in public, like if we have information from the DEP or the EPA or the National Health Association, can we use that
What was
information?
explained is if you present something that cannot be cross-examined, it's not going to be allowed.
So if I have...
This speaks for itself, essentially.
Okay, I think we'll move on. Yeah, I'm wasting my breath. It's okay. The last question I have, and I'm not sure if you can answer this or if you're the right expert, and maybe I missed it. Is this a secured site with a fence, security system, so that like teenagers who might want to hang out or something like couldn't actually get into this facility area or anything like that? An alarm system?
Well, the facility has a 6-foot-high board-on-board fence around the perimeter of the paved area of the plant, with the exception that the fencing along that faces the private street is 4 feet in accordance with with the township's ordinance.
Do you think I could climb over that fence? Oh, I know it's trespassing, but do you think I could climb over that fence?
Wait, I'm going to object. I don't think it's relevant whether this witness or anyone in the room, or a 5-year-old boy or a 10-year-old boy, we've stated what the size of the fence is. I suspect that in most houses, they don't have these 10-foot fences, and I think the witness testified the zoning limits it to a 4-foot fence in the front yard. So I don't think it's relevant what this witness can or can't do.
I agree.
Okay. Okay, so then it's not relevant if people could get close to this facility because there's nothing dangerous going on in there. I mean, in your professional opinion, is this facility, it's not an issue, not a concern?
That would not be a question for the engineer.
Okay. Oh, would not be a question for the engineer.
You're fine.
Okay, I'm done. Thank you so much.
I'm wondering if the board would not be offended if I took my jacket off because it's
Not at all, getting warm here.
Get hotter.
Hi, Juniper Lifer, 32 Jade Lane. I was actually just hoping you could clarify some of what you were just talking about with the environmental impact statement. You did submit one during the first application, is that correct?
That's correct.
But it was not required during this application?
It was not required during the first application.
It was not, okay. But one was submitted as part of the application?
As for the original application, yes.
Yes, it was. I'm just curious as to what's the discrepancy there?
Well, the discrepancy is a number of items. And primary in my mind was that there are, as Mr. Sturbins mentioned, there are a whole variety of expert witnesses and reports that have been submitted to the board that really cover the environmental aspects of the project. So therefore, it really didn't seem like it was, since it wasn't a technical requirement of the ordinance, it seemed like it made sense for each expert to address his specific portion of the environmental impacts of the project.
And can you clarify if the environmental impact statement that was given during the first application was done primarily on Lopatcong's location, or was that done for Alpha?
The answer is that there was no environmental impact statement required.
But during the first application, there was one. I'm trying to determine.
The first application, we're just discussing this.
But I don't really understand why during the same application, or a repeat of the same application, why it would be required once and not required again.
It wasn't
required on the first.
My answer.
It was provided.
My answer, as I said, is that it made sense for the professionals to each.
Then why didn't it make sense in the same way during the first application?
Be honest with you, there was really not a reason to do the environmental impact statement the first.
Maybe the environmental.
But however, we submit applications in towns, townships throughout the state.
So you just resubmit them to the next township?
And typically one is required. So we plowed forward, preparing an environmental impact statement, and did not realize until afterwards that it was not a specific requirement of the ordinance of Lopatcong Township.
Okay, so you're not able to answer for me whether or not the EIS that you did submit the first time around was for Lopatcong or for
I'm going to object to that. The witness testified he submitted an application. It wasn't required. He didn't submit with this time for this application. There's no EIS specifically, but there's plenty of environmental testimony. I think that answers the
I'll say that.
Good evening, Ron Tortello, 70 Winter Lane, Lopatcong. You mentioned earlier in your testimony that there's going to be silos at this site to be 85 feet tall. I just want to know from an aesthetic viewpoint, can you offer into evidence what this plant may look like, elevation renderings? Is there any site drawings to show what it's going to look like, and how it may impact the surrounding area?
I'm going to object to that for two reasons. First, we had an architect who's here. The trick is you ask the right witness. Wait, I'm making an objection, which I have the right to do. You ask the right witness the right question. You don't ask the civil engineer what the plant looks like. You ask the architect who was here and subject to scrutiny as to the impacts. We have a planner. You don't ask other than the engineer. If I can continue, if you have a question about the planning aspect, you ask the planner. If you have a specific question about drainage, you can ask it. But I think the question about what it looks like is the wrong witness.
Okay, so it would be appropriate for the planner?
The architect already testified.
The architect did not testify. They testified to the outbuildings and control house, not the silos or the conveyors or anything else.
Silos, we do have representatives of the company here, and as Mr. Menon said, he will be back to answer questions.
Okay, but is there any renderings going to be offered into evidence to see what this plant might look like? For instance, were there any photo studies done to show how this might impact the area? Any balloon tests or visual assessments done?
I don't believe there were, but they meet the ordinance.
I know they're not required, but in the spirit of working with the town, maybe they would be interested to see what this conceptually may look like.
Sir, that's not a question. You're making a statement.
Don't you think the town would be interested?
That's my question. Would you be interested in seeing, for the benefit of the board, a visual impact rendering of this? For instance, I have some photographs here as examples, if anyone would care to take a look at them, of a simple study I did by driving around the area and taking photographs. If there was a crane put up in the air and a balloon test done, we could see what exactly these silos would look like. Would the applicant be willing to do such a study for the benefit of the board to see what this plant visually impacts and how the landscaping would mitigate those impacts?
We have to have a conforming application. We've submitted the reports that are required by the ordinance. We're not going to be submitting a balloon test here.
Okay, I understand. I just wanted to see if that would be something they would be willing to do for the benefit of the board. So the answer is no, they will not provide that? Okay, thank you.
It's not required.
I know it's not required, but I thought that the applicant might be willing to do that just for the benefit of the board. Would they not be interested in seeing a visual of what these silos are going to impact the area and how the landscape plan will mitigate those?
Sorry, you're making a statement.
I asked if the board would be interested in seeing that.
It's not required. It can't be required.
It's not required, but would it help the board in determining how this impacts the surrounding area?
Yes or no?
It's not required. I can't force it.
I know it's not required.
You're making a statement.
It's not a statement. I would like to
Not
know.
requiring it.
Mr. Chairman, at this point in time, we're executing cross-examination. This gentleman will have the opportunity to make a statement later on in the proceedings, as is his right. This is not the appropriate time for that. This witness is here to be cross-examined on his direct testimony.
Okay, and I guess I could ask some questions of the planner, might be more appropriate as far as the visuals.
Not now, you're 5 minutes are up.
For the engineer. Thank you very much.
My name is Martin Swim from Fort Byron in Lopatcong. Just out of curiosity, as a professional engineer, how many asphalt plants have you evaluated in the same way?
Well, you have to understand that what you have to understand is it's an asphalt plant. Essentially, it's a site plan. From the engineer's standpoint, it's a matter of circulation, drainage, and layout.
I believe your answer was 0, but feel free to correct me. You mentioned there were 85-foot silos on the property. Will those be visible from the strip mall or any public roadway?
I don't know.
As a professional engineer, were you involved in the environmental impact statement prepared by Finelli Consulting previously?
Sir,
I don't intend
the environmental impact statement has already been clarified that it's not required under this application.
Correct. Would you say that the environmental impact statement lets me know something about your talent as a professional engineer, in as much as it's your work and you signed it in August of last year?
Sir, it's not applicable to this application.
Mr. Smith, you provided written evidence previously about the aesthetic value of this site. How did you base your evaluation for aesthetics?
I believe you're talking about the aesthetics that are in the EIS.
Somewhere I read about the aesthetics. Did you Did you provide any such information?
The only place that I provided information with regard to aesthetics was in the EIS, which is not part of this application.
I'm asking about your professional experience, but I can understand you don't want the answer. Is that correct?
The only thing I can tell you about aesthetics is that Lopatcong Township has seen fit that if you have a silo that in the height of that structure exceeds 30 feet, that the landscape buffer, which would otherwise be 25 feet in width, need be increased to 50 feet. And that's what we have done.
Thank you. Previous testimony has said that odors are not detectable by any instrumentation past site boundaries. Is it your professional opinion that you agree with that?
Our operations expert that's not a question for the engineer.
To clarify, that's an operations guy question. I believe you have expertise in noise. Is that true?
I do not have expertise. My expertise in noise is limited to knowing what Lopatcong Township and the state of New Jersey requires at various boundaries.
That actually is my question. So at the boundaries of this plot, what are the requirements for noise levels?
At the boundaries, since the properties around us are non-residential, then the limits around the boundary of this property would be 65 decibels on the A scale, 24 hours a day.
And as a matter of your knowledge, do you know what the permissible truck levels are at a distance of 50 feet?
It's an unclear question. Could you restate the question?
The federal government, I'm trying to restate the question. The federal government regulates noise levels from trucks. Does your professional knowledge encompass that?
I'm going to object here. This board has jurisdiction over site plan approval. It doesn't have approval over truck traffic or truck regulation. So I think questions about trucks and the noise they generate are beyond the purview of this board, and therefore I object.
For the value of the planning board, I would like to make a statement regarding the noise levels from trucks.
At the appointed time, you can make a statement to the public board. It's not a question to the expert.
I'd be willing to make a statement and present my qualifications.
You can't do that at the appropriate time. Now is not the appropriate time.
It's not a public comment. It's a statement of knowledge based on my career.
It's still a statement, and you'll be allowed to make that statement at the end of the applicant's presentation.
Thank you. In your evaluation, did you note any stockpiles of materials on the grounds as permitted by Lopat's ordinances?
Are you talking about the existing site or the proposed site?
The built final site.
Oh, it has the built out site. Well, yes, there's going to be, as was, I believe it was testified earlier, there's going to be stockpiles of aggregate material on the site.
And in your professional engineer, have you ever provided knowledge regarding whether or not a portion of this property is in a wellhead protection area?
It's been already clarified in the opening statement that there is no wetlands on this property.
I didn't say wetlands, I said wellhead protection area.
In accordance with, as per the Lopatcong Township Highlands Environmental Resource Inventory, there is an exhibit in that document that indicates that this site is within a Tier 3 or 12-year creep, if you will, area of a well that is located on the other side of Route 22 and on the other side of Dry Run, I believe it's referred to as locally.
And in your professional opinion, can runoff from this plant include petrochemicals and organic compounds?
That would not be something I would be able to answer.
Have you ever signed a statement saying that this area would have runoff, including those chemicals?
I don't recall.
On page 11 of your previously submitted report.
Your 5 minutes is up, sir.
Thank you.
Andrew Chapis, 10 Crispin Drive, Greenwich. Just a question for you, Mr. Smith.
So we didn't get to the situation.
Greenwich.
We're waiting for first Lopatcong people first. Are there any more Lopatcong people that want to question?
Anna Havens, 814 Rugby in Lopat. Anna Havens, 814 Rugby in Lopat. Why were you retained for this job?
Objection is an irrelevant question. We've been through this before.
I can't hear you.
Just trying to establish a timeline here
A timeline of what?
of when he was retained for this job.
It's not relevant.
So what? It's relevant to me.
His testimony at this point.
It's an objectionable question. It's not relevant to the scope of review of this board. I made that objection previously, Mr. Chairman, and you sustained that objection
I'm
previously.
saying it again.
Just trying to establish an idea
Ma'am, you're
of
making a
when you
statement.
were
You have a
retained in
question.
terms of the ordinance, if it was before or after the ordinance changed.
It's irrelevant.
It's not irrelevant to me. I'd like to know. That's why I'm asking. It's just for me,
It's not relevant.
to make me feel a little more comfortable.
Do you have an engineering question for this witness?
I'm sorry, I
Do
couldn't
you have an
hear
engineering
you.
question
Okay.
for this witness?
I'm sorry?
Do you have an engineering question for this witness?
The question that I asked did pertain to him individually, yes.
No, you're asking about a personal information there. He didn't testify on that.
He didn't answer my question.
He doesn't have to if it's not relevant.
Okay, I can see the scope here, so thank you.
No one else, I can go to the agreement township.
Richard Merker, 99 Maisie, Lopatcong, New Jersey. I have two questions. One is on page 11 of the report you signed saying petrochemical runoff will occur. Did you or did you not sign that, page 11?
This witness's question, because the record should reflect that the gentleman who just previously asked questions wrote the question and